All right, hello everyone. My name is Christian Jorgensen. I'm one of the legal advisors at American Red Cross National Headquarters in IHL. I also help manage the IHL Dissemination Program, which works to educate the American public on international humanitarian law, also known as the law of armed conflict, and other areas of law that touch on situations of armed conflict. Today, our presentation is Beyond the International Criminal Court, Prosecuting War Crimes at International Venues. So today's topic is a bit what comes after an armed conflict, or in some cases, what we'll find out during the armed conflict itself. Our presenter today is Professor Sarah Ox. Sarah Ox is currently an assistant professor of law at the University of Louisville, Louis D. Brandeis School of Law. Her scholarly research focuses predominantly on the prosecution of mass atrocities before international and hybrid courts and the use of transitional justice mechanisms in post-conflict and settler societies. She has presented her work on these topics at numerous conferences throughout the United States and the United Kingdom. Professor Ox serves as the co-chair of the ABA section of International Law's International Courts and Judicial Affairs Committee, as well as an advisory board member and newsletter editor of the American Society of International Law's International Courts and Tribunals Interest Group. She also serves as a volunteer international humanitarian law instructor for the American Red Cross and is a certified trial monitor with the Clooney Foundation for Justice. Before I pass it over to Professor Ox, I just want to highlight that if you're interested in becoming one of our volunteer instructors, you don't need a legal background, but you can contact your local American Red Cross office to learn more. So with that, I'll now pass it over to our presenter, Professor Sarah Ox.
Hello, everyone, and thank you so much, Christian, and everyone at the Red Cross who has set up today's program and made this all possible. As you mentioned, my name is Sarah Oaks. I am so happy to be here today. I will be talking to you today about basically options beyond the International Criminal Court. So international courts, hybrid courts that can be used to prosecute war crimes at international venues. So this is my third time coming to talk before the Red Cross about international criminal law. And I will refer back to my previous two presentations quite a bit. If you haven't watched those, you won't be at a disadvantage. I'm going to start off with kind of a brief overview about what international criminal law is and where exactly it's prosecuted. But I do believe that Kristen still has those recordings somewhere. So if you are interested in learning more about international criminal law generally, or the International Criminal Court specifically, which I will touch on but won't deal with too much today, I would strongly recommend going back and watching those recordings, which Christian can probably provide you with a link to. So to start off, without further ado, as I mentioned, I want to start off just by introducing us to international criminal law generally. So there are a lot of parts, a lot of different working parts to a definition of what international criminal law actually is. The definition that I like the best defines international criminal law as a field that renders individual criminal liability for the most severe violations of generally recognized international laws. So as I mentioned, there's really a lot of different moving parts to this. The first part of this definition that I want to focus on is that unlike other areas of law, international criminal law is focused on providing individual criminal liability for violations of international law. So this means that an actual person, a living, breathing individual, not a state or nation, will be held criminally responsible. Unlike other areas of law, international criminal law also generally does not recognize sovereign immunity, which means that heads of states, presidents, prime ministers, military officials are fair game for prosecution. They can be found guilty and they will be held accountable for these violations. Moreover, because of individual accountability, punishment is not just limited to sanctions or statewide consequences. Instead, those who are convicted of international crimes are often sentenced to actual jail time. So now that we've got individual accountability out of the way, the second part of the definition that I want to touch on is that ICL encompasses only those most severe violations of international criminal law. So in other words, those crimes that are of most concern to the international community as a whole. And while subject matter jurisdiction varies slightly from international court to international court, as we will see in a little while, generally there are four categories of crimes or core crimes that are recognized under international criminal law. These are first and foremost war crimes, which at the Red Cross we're unfortunately quite familiar with. War crimes are grave breaches of the Geneva Conventions and other serious violations of customary international humanitarian law. The second core crime is genocide. This encompasses crimes that are committed with an intent to destroy in whole or in part a national, ethnic, religious, or racial group. The third category is crimes against humanity. These are crimes that are committed as a part of a widespread or systematic attack against a civilian population. And fourth and foremost is the crime of aggression. This is the only core crime which has yet to be prosecuted by any international court. And the crime of aggression is the unlawful use of armed force by one state against another state, such as through things like an attack, an invasion, or an occupation. So now that we have that out of the way, we know what international criminal law actually entails. Now, where are violations of international criminal law or international crimes actually prosecuted? And this is again a review from the first class I taught for the Red Cross. But first and foremost, the most common place that international crimes are actually prosecuted is in domestic courts. So the courts in the country where the crimes were actually committed, as well as courts in the country where the perpetrators of the crime are citizens. So I'll use the same example that I used in a previous presentation, but consider this hypothetical. Soldiers of country A willingly and knowingly attack a civilian hospital in country B as part of a military initiative. Targeting a civilian hospital is, of course, a grave breach of the Geneva Conventions and constitutes a war crime. So because of this, the first place that these soldiers from country A can actually be prosecuted are in the domestic courts of country A to begin with. They can also be prosecuted in the courts of country B. They'll be prosecuted in the courts of country A because they are nationals, they are citizens of that country. They can also be prosecuted in the courts of country B because that's where the crime was actually committed. Generally, these domestic courts apply domestic law, and that domestic law can actually include international criminal law and international criminal law concepts to the extent that it's been incorporated into that country's domestic law. In rare circumstances, and I just want to mention this very briefly, this is a concept that we could honestly spend a full program or multiple programs talking about, but sometimes domestic courts can also prosecute crimes committed outside of their territory by non-citizens against other non-citizens. So essentially, courts in one country can prosecute crimes to which they really have no personal connection, either by territory or by citizenship. Under this concept, which is known as universal jurisdiction, a country can prosecute anyone for the most serious crimes. And these are things like war crimes, crimes against humanity, genocide. Only those countries who have implemented domestic legislation authorizing universal jurisdiction to their courts can take advantage of this, however. And again, this is a very simplified version of universal jurisdiction. It's a very complicated concept, but there is somewhat of an exception to our general jurisdictional rules here. The second venue for prosecuting violations of international criminal law is military tribunals. These are similar to domestic courts, but instead of being staffed with judges and typical attorneys, they are staffed with military officials, and they're used to prosecute members of the armed forces who violate the military law of their own country. This includes the laws of war. They can also be utilized to prosecute prisoners of war, POWs, although those POWs must be subject to the same judicial processes and procedures as the country's actual military officials. So in our previous hypothetical, soldiers from country A could be prosecuted by a military tribunal in country A, or if they are captured as POWs by country B, they can be tried as POWs before a military tribunal in country B. Generally, these military tribunals apply military codes, so laws that have been adopted by the military of that country. And all of that brings us to the subject of today's presentation, which is our third option for venues in which violations of international criminal law are actually prosecuted. These are international courts, and there are, as we will see, generally, give or take, three different types. Three types that we will talk about today are the International Criminal Court, ad hoc international courts, and hybrid tribunals. Generally, these international courts are recognized as a last resort, meaning they won't step in unless domestic courts are unwilling to or unable to prosecute these core crimes. The law that each international court and the characteristics of each international court varies slightly from court to court, but they generally always apply some type of international criminal law. So I very, very briefly want to talk about the International Criminal Court. Again, if you haven't watched the second class that I've put together on this topic, that one is devoted entirely to the International Criminal Court and talks about the ins and outs of the court. Today, obviously, the presentation is titled Beyond the International Criminal Court, so I can't spend too much time on it. But I do want to point out kind of one general characteristic of the International Criminal Court that is very necessary to really understand today's presentation. I bet a lot of you are very familiar with the International Criminal Court. I will just refer to it as the ICC from here on out. International Criminal Law loves a good acronym, so you're going to have a lot of letters coming at you over the next 40 or so minutes. But the big thing that you need to understand about the ICC is that its jurisdictional scope and its authority is very, very limited. So people might be familiar with the International Criminal Court. They see it in the news. The ICC is making progress in prosecuting and convicting defendants for international criminal crimes. So why do we need any other venue? And the reality is that the International Criminal Court is making progress, but it only has the resources and the ability to hear a very narrow set of cases. So I've included here a couple bullet points that really run through some of the primary limitations that are placed on the ICC. The first is that its jurisdiction is limited by time. The court can only hear cases involving crimes that were committed after July 2002, when the court actually was officially established. It also can only hear crimes that fall within those four categories of core crimes: genocide, war crimes, crimes against humanity, and the crime of aggression. In addition, it is limited by territory. The court can generally only hear cases that are committed on the territory of or by a national of a state party, meaning a party who has signed on to the Rome Statute that established the creation of the International Criminal Court. In addition, the ICC will only hear cases that domestic courts choose not to or are unable to hear. And they will only hear cases involving crimes that are of sufficient gravity. So meaning that they are of the most concern to the international community as a whole. And then finally, the ICC opens up some political issues, in that it can only hear cases that are brought before it in one of three ways. The first is that the UN Security Council refers a specific crime to the court to be heard as a case. Generally, this is very rare given the political dynamics on the Security Council. The second option is that a state party, a member of the Rome Statute, refers that case to the court. And the third is that the prosecutor opens the case on his own initiative. So again, what I want you to take away from this so far is that the International Criminal Court's jurisdiction and power to hear cases is limited. It just doesn't have the resources, it doesn't have the ability to hear all of the international crimes that unfortunately are occurring today. So as a result, we have to rely on other venues, other types of international courts. And I want to backtrack a little bit right now, back to the creation of what are called the ad hoc tribunals. And these actually predated the International Criminal Court. In the 1990s, two huge sets of atrocities occurred in very different geographical areas. The first occurred in the Balkans with a series of civil wars in the former Yugoslavian Republic, which ultimately escalated into persecution and ultimately genocide of Bosnian Muslims by Serb forces. The second happened in 1994 in Rwanda, with the genocide when ethnic Hutu forces took power over the country and systematically killed and committed a genocide against close to 1 million ethnic Tutsis. So in response to both of these atrocities, which the UN viewed as violence that posed a serious threat to international stability, the UN Security Council passed resolutions which created two distinct, what they called ad hoc or as needed international criminal courts to prosecute the worst perpetrators of both of these atrocities. One of these courts, the International Criminal Tribunal for the former Yugoslavia, was created to prosecute, obviously, the crimes that committed in the former Yugoslavia. The second court was created to prosecute genocide and related crimes that occurred during the Rwandan genocide. Each had a temporary mandate, meaning that it was only intended to be in existence for several years, and it had a limited budget. These were the first international criminal courts that were created since the Nuremberg and Tokyo tribunals at the end of World War II. And remember, at this time, we're still in the 1990s. This is before the ICC negotiations really took off, before the ICC was really even a realistic possibility. So there was a lot of unknown at the time that the ad hoc tribunals were created. These ad hocs really kind of set the stage for the courts coming after them. So just to touch on each of these courts a little bit individually, I'll start with the first ad hoc court that was created, which is the International Criminal Tribunal for the former Yugoslavia, also known as the ICTY. In the ICTY, all of the lawyers and 11 of the judges, all 11 judges were international. Again, it was created by the UN Security Council. The UN appointed all 11 judges, and the court was based in The Hague. It had primacy, meaning it had kind of the premier jurisdiction to hear cases related to the Balkan Wars, meaning it had primacy over the national courts in the former Yugoslavia. It had a lot of significant accomplishments, as you can see through this infographic that the ICTY provides on its homepage. It ultimately indicted 161 individuals, and out of that number, it ended up sentencing 90 of those. So by statistics alone, this court was viewed kind of as the golden child of international criminal courts, given the number of convictions that it secured. But in addition, it also created significant case law. So again, this was the first court after the Nuremberg and Tokyo tribunals. It was before the ICC, and it was one of the first courts that created kind of a significant body of jurisprudence regarding genocide, or regarding, crimes against humanity and war crimes. It was also the first court to convict a defendant of genocide, and the first to indict a sitting head of state. The court indicted Serbian President Slobodan Milosevic, who unfortunately died before his trial ultimately concluded, but that was a huge success for the ICTY. The second ad hoc court was the International Criminal Tribunal for Rwanda. This was created again by UN Security Council resolution in 1994, so a year after the ICTY. It had a very similar setup as the ICTY in that it was funded and staffed purely by international judges and lawyers. But interestingly enough, the ICTR really had kind of a controversial creation. So the UN Security Council voted nearly unanimously to pass the resolution that created the ICTY, but there was one country who voted against that resolution. And I'm sure a lot of you probably don't suspect this, but that country was Rwanda. Rwanda did not support the creation of the court because it was insistent that the death penalty be imposed on defendants. And under customary international law, the death penalty is not recognized as an appropriate punishment. So as a result, from the get-go, the court did not secure Rwandan support, and it posed some critical issues from the beginning. So the court itself was not based in Rwanda. It ended up being established in Arusha, Tanzania, so several countries over, and it faced significant issues when it came to evidence gathering and obtaining witnesses, because the Rwandan government just was reluctant to provide support in evidentiary issues. However, even despite these critical issues, the court still had a number of great accomplishments. So as we see here, the statistics, while a little bit less than the ICTY, are still pretty substantial. The court indicted 93 individuals and sentenced 62 of them. It was the first court to address the issue of war crimes in a non-international armed conflict. It issued significant jurisprudence on genocide and crimes against humanity, especially crimes of gender violence. And while the ICTY was the first court to indict a sitting head of state, the ICTR was the first international court since the Tokyo Tribunal to convict a head of state, with the conviction of Jean Kabanda, who served as the Prime Minister of Rwanda at the start of the genocide. So jurisprudentially and statistically, the ICTR did, like its predecessor, the ICTY, obtain great, significant accomplishments. So as you could tell from the previous slides, both the ICTR and the ICTY are now closed, but that doesn't mean that all of the cases that were before those courts have been resolved. Instead, while the ICTY closed in 2015 and the ICTR closed in 2017, the UN created what is called the International Residual Mechanism for Criminal Tribunals, which remains open and ongoing. It's currently hearing several appeals and wrapping up kind of those residual functions and remaining issues that lived beyond the life of the ICTY and the ICTR. It currently has two branches, one in The Hague that primarily handles the residual functions of the ICTY, and a branch in Arusha, which handles the residual functions of the ICTR. These residual functions include a whole bunch of things, including tracking and prosecuting remaining fugitives who have not yet appeared before the courts, conducting retrials and appeals, protecting victims and witnesses, enforcing sentences, and preserving and managing archives. Like I mentioned before, it's still hearing some very high-profile cases, but just to give you a highlight of some of the most famous cases that came before the residual mechanism. One of these was the appeal of both Radovan Karadzic and Ratko Mladic, aka the Butcher of Bosnia. So these two men were convicted by the ICTY trial chamber of genocide and war crimes and crimes against humanity related to the Bosnian wars, and specifically their role in orchestrating and conducting the Srebrenica genocide, the Srebrenica massacre. The appeals chamber of the residual mechanism affirmed the trial chamber's convictions against both defendants a few years ago, and both men are now serving life in British prisons. Another high-profile case that's currently before the residual mechanism is that of Felician Kabuga. He was one of the fugitive genocidaires from Rwanda who went into hiding shortly after the genocide concluded, and he was arrested, some of you may remember, in May 2020, right at the start of a couple months into COVID, so it was really big news. He was arrested in Paris for his role in the genocide. He's currently appearing before the Hague branch of the residual mechanism due to health concerns that prevent his travel to Arusha. So that's going to be a really interesting case to watch. Okay, so I just spent a significant amount of time talking about all of the great things that happened before the ICTR and the ICTY. However, despite these accomplishments, the ad hocs weren't without challenges or criticisms. So both the ICTR and the ICTY were very expensive. They exceeded their budget pretty much tenfold and ended up lasting, each of them ended up lasting about 20 years, which was much longer than their original mandate was intended. There was minimal victim involvement in the operations of the court. Both were very far removed from the victims and the location where the crimes actually occurred. And on top of that, the UN really didn't provide very significant outreach to kind of keep the victims and the people of the former Yugoslavia and Rwanda engaged in the proceedings and the developments before the court. So as far as many of the locals in these countries were concerned, the victims themselves did not receive actual justice. These courts were simply a far away, judicial mechanism that imposed justice that didn't really affect the victims realistically or practically in any means. So as a result of these issues, beginning in the late 1990s, again, right around the time that the ICC was being negotiated, scholars and practitioners and advocates began to start implementing this idea of creating a hybrid model of prosecution that kind of blended the best of both worlds. So it would bring in local involvement and ownership over the judicial process and combine this with the legitimacy and the resources that were afforded by international courts to address some of those primary concerns with the two ad hoc tribunals. So under this method, this hybrid model of justice, there would be a combination of elements of domestic law and resources with international law and resources. And you would see this through a variety of different components. The first would be through the law that was actually applied by that tribunal. They could apply international substantive law, domestic procedural law, or a mix of both. The hybrid model would also combine the use of domestic lawyers and judges and staff with international judges, attorneys, and staff who would be working side by side at the courts. And finally, it would combine funding from both international actors and the domestic funds. So unlike the ad hocs or the ICC, the hybrid model of prosecution is very much not a one-size-fits-all approach to justice. Instead, each court is governed by a different statute, and each of these statutes are tailored to specifically adjust and adapt to the specific crimes and circumstances that gave rise to the court. So it's really difficult to kind of pigeonhole one approach to hybrid justice. And in fact, we'll see this in a little while, there is kind of a spectrum of hybrid courts ranging from very domestically based hybrid courts to very internationalized hybrid courts, depending on kind of the composition or the makeup of the international and domestic resources that each court has implemented. So these courts, again, they're not all created by one specific means. These vary based on the hybrid courts, but generally they're created first by bilateral agreements, so agreements between an international organization like the UN or the EU with the domestic state government where the atrocities occurred. They can also be created by UN administrations. So those administrations that have been created by the UN Security Council to effectively help a government in a post-conflict state transition to a peaceful government or peaceful democracy. They can also be created as the ad hoc tribunals were by UN Security Council resolution. And finally, they can be adopted into domestic legislation and created purely within domestic legislation by the state where the atrocities occurred. So at the time that these hybrids were established and they started being envisioned to address all of the issues with the ad hoc, there were a number of goals that the creators of the hybrids had in mind when they were kind of setting up. And theoretically, these goals are amazing. They are wonderful objectives, and they really seek to kind of combine domestic and international involvement, as the court's name suggests. So the first goal that these courts had was this concept of capacity building. So it was this idea that by having local judges and lawyers in post-conflict states work alongside these experienced and highly trained international lawyers and judges, this would help the international officials train their local counterparts in human rights and fair justice procedures to make sure that they were capable of conducting and prosecuting cases in line with international standards. The hope for this was that once the hybrid tribunal concluded its mandate and closed, these local judges and lawyers would be able to return to their domestic courts with this new training, with this new knowledge, and be able to really effectively prosecute human rights violations. The remaining goals all kind of stem from this idea of incorporating more local ownership or local involvement, victim involvement into the judicial process. The second goal was that it would provide the country, the post-conflict community or state where these horrible atrocities were committed, with a sense of transitional justice. It would help promote peace between the two conflicting entities or multiple conflicting entities in the conflict. It would promote reconciliation, and it would restore some stability to that post-conflict state. It would also give victims the opportunities to actively participate in proceedings and feel like they were a part of the judicial process rather than just seeing justice unfold from half a world away like we did with the ad hoc tribunals. And then the last goal, or one of the last goals, was that it would promote greater legitimacy of the court's ruling within the state. So it would no longer be a far removed institutional mechanism imposing laws that weren't relevant to the state itself, but instead the local people would respect and honor the judgments that were issued by the hybrid court. So with all of these really lofty goals in mind, about a dozen hybrids were created over the next decade or so in various geographic areas. This included East Timor in Southeast Asia, Cambodia, Sierra Leone, Bosnia, even Iraq. And so I mentioned before, while there was a number of hybrids, each one of these was very different in the amount of domestic and international resources that it combined. And unfortunately, we don't have time to go through every single one of these hybrid tribunals. So I'm going to spend the remaining amount of my time focusing on 3 of them. And these are the 3 that are still in existence. So the Cambodian Hybrid Tribunal, the Special Tribunal for Lebanon, and the Kosovo Specialist Chambers. So the first hybrid court that I want to talk about is the extraordinary chambers in the courts of Cambodia. And this is a really big tongue twister. So I'm just going to refer to it either as the Cambodian Tribunal or the ECCC. The ECCC was one of the first hybrids to be established. It was created to prosecute those individuals who were most responsible for the atrocities committed by the Khmer Rouge regime in Cambodia between 1975 and 1979. So obviously, given that all of these crimes were committed in the 1970s, these crimes would not fall within the jurisdiction of the ICC, given that the ICC's temporal jurisdiction begins in 2002. So to back up, between these 4 years, 1975 and 1979, under the leadership of Pol Pot, the Khmer Rouge regime ended up becoming responsible for the deaths of nearly 2 million people and decimating approximately 20% of the Cambodian population. So in the 1990s, the Cambodian Prime Minister, who is actually still serving today, his name is Hun Sen, he reached out to the UN for assistance in creating a court to prosecute those people most responsible for the Khmer Rouge atrocities. The UN ultimately agreed to create the hybrid tribunal, but there was very extensive, prolonged, complex, somewhat hostile negotiations between the Cambodian government and the UN about how much power each of the entities would have. So Hun Sen, who ironically or interestingly was a former Khmer Rouge official, he wanted the Cambodian tribunal to retain pretty much full Cambodian power. So he essentially wanted a tribunal that had international funding and was operated exclusively by Cambodian officials. The UN, of course, obviously was not on board with this. So they wanted more of a traditional hybrid. They wanted to kind of split the baby essentially and have international judges and Cambodian judges. And after about 6 years of negotiations, they finally reached a bilateral agreement to create the ECCC. And it ended up being stylized more along the lines of what the UN was looking for. It was a traditional hybrid tribunal. It was set to be located in Phnom Penh in Cambodia, where many of the atrocities were actually committed. It was staffed with Cambodian and international judges, prosecutors, and administrative staff, and it ended up applying international substantive law and Cambodian procedural law. So the tribunal officially opened in 2004, and like I said, it's still in operation. So since its creation, the ECCC has indicted 9 individuals for their roles within the Khmer Rouge. but it has only convicted 3 of them. And these are convictions for genocide as well as crimes against humanity. Since these convictions, however, the ECCC has devolved into somewhat of a stalemate. So the progress of the tribunal has really stalled in recent years. And this is largely because of somewhat of a standoff between the Cambodian and the international arms of the tribunal. So the Cambodian judges and prosecutors, ostensibly under the influence of Hun Sen's request, have taken the stance that there should be no more prosecutions, there should be no more convictions beyond the 3 defendants who have already been convicted. Their argument is that the remaining defendants, and there are 4 of them who remain pending trial before the ECCC, do not qualify as senior leaders of the Khmer Rouge and thus don't fall within the court's jurisdiction. The international prosecutors and judges, of course, take the opposite view, which is that these remaining 4 defendants need to be tried and should be convicted before the court in order for the court to fulfill its mandate. However, at this point, really neither side is budging, and as a result, these cases are not moving forward. So with that in mind, and the fact that a lot of international criminal law and criminal law in general is based on numbers, the number of convictions and indictments before the ECCC, especially when compared with the hundreds and near hundreds of indictments and convictions that were gained by the ICTR and the ICTY, is a little bit less than stellar. So we have 9 indictments and only 3 convictions after about 20 years in operation. But looking beyond this, and this is difficult to do, but I'm a huge proponent of the ECCC, and I think it's made a lot of headway. The ECCC was instrumental in allowing Cambodian victims and their families to be a part of the judicial process, and it really granted them ownership over the judicial proceedings that would have been lacking in a purely international court. The tribunal adopted the civil party process, which essentially allowed victims to participate as parties in civil proceedings that ran concurrently to the criminal proceedings before the tribunal. And it gave the parties an opportunity to really serve as witnesses and share their stories, which was instrumental in kind of moving transitional justice forward in Cambodia. The court also engaged in substantial outreach. So it bussed hundreds of thousands of Cambodians in from rural areas to actually attend and view the proceedings before the court, which was momentous for those victims of the Khmer Rouge. And it also developed significant international criminal legal jurisprudence. It was the first hybrid tribunal to convict a defendant of genocide, and it also developed significant jurisprudence on issues related to joint criminal enterprise liability. So while the ECCC represented a true hybrid tribunal and that it was staffed, it blended international and Cambodian law, it was placed in Phnom Penh, Cambodia. The next tribunal that I'm going to talk about, Special Tribunal for Lebanon, leans a lot more towards the more internationalized end of the hybrid tribunal spectrum. It's much closer to an ad hoc tribunal than a domestic court, in that it had very minimal local involvement outside of its funding. So the Special Tribunal for Lebanon is an extremely unique tribunal, and I'm going to tell you all the ways in which it is so. But it was originally established in 2009, and unlike most other courts who we've seen have mandates and jurisdictions that encompass like long periods of human rights violations or atrocity crimes, the STL, the Lebanon Tribunal, was created to prosecute really one primary crime, which was the bombing attack of February 14th, 2005, which ultimately killed 22 people in Beirut, Lebanon, including Lebanon's then former Prime Minister Rafiq Hariri. So again, unlike most of the other hybrid tribunals that are based in the country where the atrocities were committed, the Lebanon Tribunal sits in The Hague in the Netherlands, and it was established by a resolution passed by the UN Security Council. Its funding is composed of 51% international funds and 49% Lebanese funds, and it's composed of a majority of international judges and a minority of Lebanese judges. It's also the only international criminal court whose mandate includes the distinct crime of terrorism. So generally, terrorism isn't recognized as a separate or distinct core crime. Part of its act can be lumped in, depending on the circumstances in which the act is committed. It can be lumped in with several of the other core crimes. However, the STL statute recognizes it as a distinct crime under its jurisdiction. It's further distinct in that it's the only international criminal court that allows trials to be conducted in absentia, meaning that trials can be conducted without the defendants actually present or in the custody of the tribunal. And in fact, the one substantive trial that the STL has actually conducted so far has been in absentia. This trial was against 4 defendants, none of whom appeared before the court or in the custody of the tribunal. And it included charges related to terrorism and these defendants' alleged role in the terrorist attack. The trial chamber ultimately ended up acquitting all but one of the defendants. Salim Jamil Ayash was convicted of conspiracy to commit a terrorist attack, intentional homicide, and premeditation by using explosive materials, among other crimes. And while this was seen as a big accomplishment for the court, again convicting only one defendant, despite several years in operation, the STL has largely been viewed as unsuccessful. And the court's issues were really compounded last summer when the court publicly reported that it was enduring a significant financial crisis and said that it wouldn't be able to conduct operations beyond July 2021. So it actually canceled the commencement of a second trial and halted the appeal of its first trial. And while many experts were expecting the tribunal to close its doors immediately, it's still in operation today. So after several months, scholars have commented that the court is running on life support, but it is in the process of commencing the appeal for its first trial, but it's really kind of touch and go about where the future of the STL will lead us. And then I know I'm kind of running out of time here, so I just want to briefly touch on this third and last court, which is the Kosovo Specialist Chambers. It's the most recently created hybrid court. As its name suggests, it was created to prosecute crimes against humanity and war crimes committed during the Kosovo conflict between January 1998 and December 2000. This is an extremely controversial court, and as I was mentioning that spectrum before, from domestic to international, it's almost entirely an international court. Really, there is very, very, very minimal involvement, and in fact, a lot of Kosovo public opinion rests against the court. And there are several reasons for this, and the big one is that the Kosovo Specialist Chambers jurisdiction focuses primarily on crimes committed by one group, the Kosovo Liberation Army, which most of Kosovo views as heroes, as the group that essentially got Kosovo its freedom from Serbia. Specifically, investigations reveal, however, that the KLA engaged in unlawful detentions, torture, kidnapping, and to some extent even organ trafficking. So these are the crimes that are really falling within the focus of the court's jurisdiction. And so a lot of Kosovo locals are seeing this court, which is based in The Hague, which is staffed entirely by international judges, no local staff whatsoever, as very similar to the ad hoc tribunals in that it's this faraway justice that's imposed on them without their consent. So given this controversiality, the UN really has kind of minimized the local involvement in this court. And in addition, it's kind of leaned into its controversial nature. So in 2020, the KSC prosecutor, the Kosovo Specialist Chambers prosecutor, actually indicted the sitting Kosovo president, Hashim Thaci, whose picture is in this slide. And Thaci, along with 3 other defendants in his case, are all high-ranking KLA leaders who are very popular in Kosovo. So they've all been charged with crimes against humanity, including torture, murder, forced disappearances, and other related war crimes. So President Thasi ended up stepping down from his role as president in order to appear before the court, but it caused a lot of outrage, and it just has continued to paint the KSC as a very controversial court. So to date, the prosecutor of the Kosovo Specialist Chambers has indicted a total of 6 defendants within its substantive mandates, as well as 2 additional defendants for contempt crimes. It started its first trial in September, and it will be very interesting to kind of follow how this very controversial and interesting court finishes up its mandate. Oh, okay. So with all of that said, I think we can all recognize that there are some themes that kind of stand out with regard to hybrid courts, and that while they aim to solve a lot of the problems of ad hoc tribunals, they have encountered their own set of challenges. And a lot of these stem from some of the same issues. The first is the lack of local governmental or political support. And as we've seen in both the ECCC and with the Kosovo Specialist Chambers, this can be a serious detriment in that these local governments will not turn over evidence, they won't provide witnesses, and they won't help with investigations. And kind of tying in with this issue, one of the other common challenges that plagues international or hybrid tribunals are evidentiary issues. So things like witness tampering, which has been a problem with the Kosovo Specialist Chambers, or the passage of time between the commission of the crimes at issue and the trials, which, as we've seen with the ECCC, there were about 3 decades that passed from the time of the crimes to the actual trials themselves, which proved extremely difficult for the prosecutor to gather evidence. And then the third challenge is that often results are not aligned. The results that the courts have, namely the handful of convictions that they end up with, are not aligned with local expectations. Locals are kind of expecting a court like the ICTY to come in and prosecute hundreds and hundreds of individuals, and ultimately, due to resources and due to other evidentiary issues as mentioned above, as mentioned before, this doesn't always happen. There might only be a handful of convictions. So these are all challenges that scholars and advocates are considering as we decide what the future is really going to look for in the field of international criminal tribunals. So again, while we have the ICC that is still in operation, obviously, and handling a number of cases, as we mentioned before, there are a wide range of cases that fall outside of the scope or the reach of the ICC. So given all of the issues that the hybrid tribunals have encountered, the future of hybrids remains really uncertain. I think a lot hinges on the performance of the Kosovo Specialist Chambers in determining how this hybrid model of prosecution is used moving forward. But given the issues that have plagued a lot of the courts in the past, states have become pretty hesitant towards using this model of prosecution and adjudication. So the future, however, might lie in something that's in a type of mechanism that's been around for a while. And these are called fact-finding and investigatory mechanisms. They've been used in the past to essentially engage in what it sounds like: fact-finding and compiling records regarding past atrocity crimes or series of human rights violations. However, in recent years, the UN, these mechanisms that are created by the UN Human Rights Council, the UN Security Council, they have begun creating these mechanisms with more of an eye towards future prosecution. So, for instance, there are currently investigatory mechanisms being used to investigate atrocities committed in Syria, Sudan, crimes by ISIS in Iraq, and crimes against Rohingya Muslims in Myanmar. And for some of these, especially the Myanmar investigatory mechanism, this is still a fact-finding and record compiling mechanism, but they also are tasked with compiling legal files to be used at future prosecutions. So this is a big kind of change from how prosecutors were acting with the hybrid tribunals, in that they were essentially waiting until after the atrocities were finished to kind of gather their evidence and present them before the tribunals. Here we have evidence gathering and people on the ground investigating while these atrocities are still going on. And we have legal files that are ready to be used in prosecution before another court. The only big drawback, I would say, to these investigatory mechanisms is that they are investigatory. They are not judicial mechanisms. So they are not attached to a specific court. They do not have any judicial authority. They can't prosecute. They can't convict. So all of the evidence that they are gathering is going to need to be used at a different court. So this could be a court like the ICC. This could be domestic courts, or this could be a new round, a new era of hybrid or even ad hoc courts. But at this point, it's a little bit early to tell kind of where the future is moving with this field of law. So it's going to be a really interesting couple of years, I think, to see what happens with international courts and tribunals. So with all of that, I know I kind of just overloaded you all with information. I've included my email here. If you have any questions or want to discuss anything further, please shoot me an email. I will also stick around. I know Kristen is going to be handling the Q&A, so I'm happy to hear your thoughts and questions.
All right. Hi, Sarah. Well, thank you so much for your presentation. We have about 9 minutes left in the hour, so I'm gonna, if I don't get to everyone's questions, if you don't mind, I'll forward you the ones that I think probably will take a little longer of explanation, that we can get through as many as possible. So the first question speaks to a situation in El Salvador. And it's not so much a hybrid court, but it does have to do with accountability for violations of international law, specifically genocide in this case. So the question is, what has happened, if anything, with El Salvador, where the president overturned the court's prosecution to genocide?
So to be quite honest, I'm not entirely sure. I haven't been following El Salvador, but Christian, do you happen to know this?
Yes. Well, I know a little bit about it. So it wasn't so much that it was the president overturning the court's prosecution to genocide, than it was the president vetoing legislation that would allow for prosecution to occur in the first place. And I think that speaks to just the principle of law in general, where usually courts mandates usually come from sort of governing document that comes through a legislative process. In most cases, we have the Constitution, which lays out certain jurisdictional provisions for our court systems. And of course, then, governments and whoever has the authority can add on to those jurisdictional boundaries. But in this case, I know the El Salvadorian legislature barely passed a bill that would allow for prosecution to occur. And then the president vetoed it. Now the Congress of El Salvador, whatever the legislative body there is, can overturn that veto, but it requires more votes. So since the legislation itself barely passed in the first place, you have to get more people who didn't vote for it in the first place to therefore vote for it again, which is unlikely in that case. So it's an interesting case. It's not so much a hybrid case, but it talks about legislatives either stymieing or promoting accountability.
And I will just jump on, Christian, if you don't mind. That's one of the biggest issues, I think, with hybrid courts and just prosecuting international crimes generally. Is usually there needs to be kind of a change in a regime change, or just different people coming to power that don't have connections to that prior regime which was engaged in the atrocities, because without that, you're just not really going to have that political support there to proceed with prosecution. So that's one of the biggest drawbacks, I think, with international criminal law.
Yeah, I would agree with that statement. The next question is, when was the Cambodian court established, if you know the year offhand?
I want to say, I believe the legislation was incorporated into Cambodian law in 2003, and it ended up becoming effective in 2004. It was the early 2000s, so it was about 30 years after the fall of the Khmer Rouge, or 25 years. So there was a big disparity in that. But it is still, as I mentioned, it's been ongoing for about 2 decades now.
All right, and that date sounds about right to me, somewhere in that 2003, 2006-ish yearish range. The next question is, what exactly do residual mechanisms for criminal tribunals for that of Yugoslavia, for example, do, and how are they different from just keeping the tribunal open?
Right. So first of all, hi, Sarah. Thank you for joining. The residual mechanism is kind of one of its kind currently. So there have really only been a handful of international courts that have really wrapped up and kind of closed their doors. The residual mechanism, from what I understand, is kind of like a more narrowed version with a lot less resources, a lot less workers, and a lot less funds than what the ICTY and ICTR were using just as a whole. It's kind of a pared down version of those courts and really only used to engage in the functions that are critical to wrap up the tribunal. So really finishing those cases that the court didn't or couldn't finish, those very few cases, or those cases where they couldn't find the defendants, where they were still fugitives. The residual mechanism is, again, just very kind of a pared down version.
All right. And we have two questions from the same person. And so I'll go to their second one because I think it touches more on your presentation. But this person says that they understand that different countries have significantly different legal systems. Does a hybrid tribunal reflect the national legal system?
Depends. So that's pretty much my answer for every hybrid. So as I mentioned, it's really it's not a one size fits all. It's a very unique process from hybrid to hybrid. But the Cambodian tribunal, I know, followed the civil law system. So it was really based around the civil law system that's used in Cambodia as far as investigation and prosecution. So it was broken up just like the Cambodian court system is, with a pretrial chamber, a trial chamber, appellate chamber, and an office of investigating judges. So that's the same is true of the Kosovo specialist chambers in that it's technically linked to the domestic court system in Kosovo, but really that doesn't say much in terms of rhetoric. It's linked, and in terms of domestic legislation, it's linked to the Kosovo judiciary, but it very much operates completely independently of the Kosovo courts. So again, it depends on the specific hybrid.
All right. And then the other part was questions about a specific crime. So the crime of aggression, which this person understands to be as one country against another. So who would be charged as an individual under ICL on international criminal law, or is this something where you would, is it more of a state responsibility thing that's going to be more civil than criminal, even though it is a crime under the Rome Statute?
So I think there is definitely a civil aspect to this that could be handled, say, before the International Court of Justice for a violation of the UN Charter, say. But the specific crime of aggression does target individuals. So obviously the only people that will be, or not obviously, the only people that will be held criminally liable under the crime of aggression will be those people who have the power to actually instigate attacks or occupation against another country. So these are going to be the bigwigs, the president, prime minister, or head of the military. So the crime of aggression is going to be very limited as to who can actually be prosecuted under that. And like I mentioned, we haven't seen any prosecutions at the ICC for that crime yet, but I do think that we can expect it at least within the next 5 or so years. But those would just be against the big guys in charge, or big women in charge.
Yeah. So the next question is I think it's about evidence, evidentiary standards, and it's would there be issues with generic investigations having acceptable forensic processes that are useful in a wide variety of possible courts? And I take that to mean, does each of these courts, hybrid courts, have its own evidentiary standards, et cetera, or is there some type of universally accepted process for admissibility, but also the forensic side of it? I don't want to take that away from the question.
Yes, so I don't know how effectively I can speak to this, but I do know that each statute has kind of its own evidentiary procedures for evidence gathering and usage at the courts. However, they are generally, I think, pretty much the same. There are also different protocols that have recently come out. I know the Berkeley Protocol kind of talks specifically to social media evidence, which is a new big field of evidence that's being used in these international criminal prosecutions, but I don't think there's any kind of just one clear standard.
Okay. And then I think this goes back to our talking about El Salvador. So we just talked about how the president vetoed this legislation. What's the process of either involving the ICC or creating some type of hybrid or ad hoc stuff? So maybe you can talk about the procedural stuff. I know you've touched on that before, but maybe just highlight in this context. Is there an international mechanism?
So as far as the hybrid goes, I would say a hybrid court is probably out of the question, since it will largely have to have at least some input from the El Salvadorian government. As far as an ad hoc being created, I mean, the UN Security Council can always step in and create that under their authority pursuant to the UN Charter. However, it's probably unlikely that they would do that because there needs to be kind of a clear threat to peace and stability, international peace and stability. At the same time, the UN Security Council could also refer the situation in El Salvador to the ICC. But unfortunately, given the permanent members and their veto power on the UN Security Council, it is a very politically fraught procedure. So it would need input from all 5 of those permanent members in order to get before the ICC.
Yeah, and even when something's referred to the ICC, I mean, resources are limited to the point where they can't possibly address everything. So that's also under consideration, I'm sure, as well. Well, thank you, Professor Oakes. I'm glad that I finally got your last name correct, but thank you again so much for your presentation. For those questions that I didn't get to, I will be emailing those to you. And if you have a chance, I know those people would appreciate you reaching out. So thank you again. For all of those who are still in attendance, please see the link in the chat at this time, www.rulesofwar.org/webinars for all other IHL related or international law related webinars that the American Red Cross is hosting. So thank you again for all who attended, and I hope to see you at our next event. Thank you.
Thank you.